Kyle here, this superstar to my left, he was my honours student last year, and he completed his thesis, and not only did he score first class honours, which we were very delighted with, pretty rare in the place, I'm happy to say, depending on your perspective. But he's now decided he wants to take this show on the road, and that's partly why we're here. As for the topic, I'm actually just an employment lawyer, not a torts lawyer, so it is a topic that I dabble in, but he's now become the expert, which is very nice to see actually. So it's his presentation, and he's an absolute superstar, and I'm sure he's going to show you why. Thank you.
Awesome, thanks Giuseppe. All right, guys, so as we already mentioned, we are talking about the legal limits to liability for participants in sport. It's all fun and games until someone gets hurt. Then it ends up viral on YouTube. So our next thing here is why consider negligence. This is going to be the main focus of our presentation today, guys. And the reason for this is a current case study here as Alex McKinnon, who was recently injured in 2014 season during an NRL game. Now, Alex was injured severely to the point where it ended his career. We're not going to delve into the details of Alex's case, but we are going to examine a couple of the ways that these injuries are generally handled. First of all, it goes to a league tribunal. With the league tribunals, though, we have a bit of a problem because as you leave the league tribunal as the one who was injured, you actually end up being the biggest loser of the whole thing. These are only pecuniary, guys. They don't provide any sort of compensation to the actual injured party itself. And as such, they don't serve very well for helping those who are actually damaged the most by any of these illegal moves. Next, though, there is insurance coverage, which for the most part is quite inadequate. Now, I must admit, in 2015, the NRL's insurance policy changed dramatically after Alex and is now quite good with $1 million as a career-ending payout. However, for Alex's case and for many others in other leagues, these insurances are still quite inadequate. For Alex, in his situation, he had to rely on over $1 million publicly donated to help pay for medical expenses, let alone any future cost of living from completely losing his primary source of income and any future viable career in that sport. So with this, you have to consider, what if it was less publicized? What if it happened to someone who wasn't a superstar in their sport already? Would they get that same kind of public donations? And if not, what are their options? And honestly, when it comes down to it, for the majority of people, their last option is going to be suing in a court of negligence, or sorry, in a court of law under torts, specifically negligence. So what we're going to look at now is Australia's legal history. For those of you who aren't too legally minded, simply understand this. There are two ways that tort law has gone in Australia: prior to the Civil Liability Acts and following the Civil Liability Acts. Prior to, we dealt solely with case law. And in that, we need to find a couple of things. So through case law, we did establish that there is a duty of care. What this means is that between participants, they each owe each other a legal duty. Now, the exact determination of this duty falls in our orange section, the standard of care, and is often done through a term called additional risk. This stems from a case Roots and Shelton, which was done in 1967 and still stands as the best authority to date, as it was from the High Court of Australia. Now, following that, we have several defenses. Prior to the Civil Liability Acts, we only really had volenti non fit injuria, which is voluntary assumption of risk. The reason this was quite important is it deals with this issue of inherent risks. Because guys, what separates sports negligence from regular negligence is when you go onto that sporting field, there are inherent risks that you must assume will happen to you as just a product of you playing in that sport. So there was a lot of confusion between whether or not those risks are assumed voluntarily as a defense to negligence, or whether those should be how you determine where negligence is drawn. At what point do you say that went beyond the inherent risks? Now, things got a little bit more complicated following the Civil Liability Acts, because instead of putting limitations at the standard of care where you determine liability, they instead put it in the defenses. There were several done, but for the purpose of this, we're going to talk about the dangerous recreational activity defense. This defense pretty much became a blanket coverall for excluding certain liabilities in sport. In the next slide, we're going to go into it in a bit more depth. But understand that the two big players today are going to be our additional risk in our standard of care, a determination of negligence, and our defense of the dangerous recreational activity, which was, of course, a defense to negligence. As far as vicarious liability is concerned, it's well established before and after the Civil Liability Acts that you are going to have a club potentially liable for any damages their players cause to others. Now, the problems with our current approach, the additional risk here, what we need to talk about here is that the policy is essentially a risk that would not necessarily or ordinarily occur will breach our standard of care. Now, what is necessary or ordinary? That's determined by the courts at what we call a reasonable person. So in that position, what would a reasonable person do? Was the injury foreseeable? Was it something that was not very insignificant as well, is something we need to talk about. On the other side, you have our dangerous recreational activity defense, which states, roughly speaking, that obvious risks in recreational activities with significant risk of harm carry no liability. That significant risk of harm is how they determine what is a dangerous recreational activity. Now, what is an obvious risk? That's also determined by our reasonable person in the place. But it's far more expansive than that. It also covers common knowledge, things that have a low probability of occurring, and finally, events that aren't even physically observable sometimes. So as you can see, the way you would like this to work is to have liability determined more on a general stage in the standard of care, and then use the defenses to filter out those that you specifically didn't want liability to arise for. We have the opposite at the moment. We have a more narrow approach through our standard of care determining liability, and then a very catch-all for our defense, which basically means nothing's going to make it through there. Now, the one little caveat here, though, is that we have a significant risk of harm, and that kind of stops it, limits it a little bit. The problem is, it's never said in the legislation, and this is Australia-wide, what a significant risk is. Obvious risk is well defined, but a significant risk is never mentioned. Now, we have Justice Ip, who approached this from a general perspective, saying any sport with a significant risk of harm is a dangerous sport. Done. Rugby, dangerous. Tennis, potentially dangerous. If you can prove that it's a significant risk of harm, it can be dangerous. This is really quite a dangerous way to go about things, as you're going to exclude a lot of sports where it possibly wasn't appropriate. It mentions this and actually discusses it, but finds no way around the wording of the laws itself. On the contrary approach, we have Baston, Justice Baston, who says that there's more of a specific approach to significant risk, and that it's really talking more about the actual event and whether or not that tackle represented a significant risk of harm, as opposed to saying just in general rugby has a significant risk of harm. Unfortunately, Baston's view ignores the fact that the legislation puts obvious risks as our main determination of where that risk lies. The way it's written and the way it's worded, obvious risks are meant to be our main factor, as it is more explicated in the legislation. Ip himself, who helped draft part of these legislations by coming out with the Ip report, which they were modeled upon, also concurs with this. So we have a bit of an issue here where our legislation is actually a bit uncertain and certainly confusing to most players, especially where their rights stand. So in order to try and fix this or potentially find out what might be a better solution, we turned to another country for a study. We ended up settling upon Canada after exhausting the United Kingdom and the United States as well. We won't go into the reasons they were exhausted for reasons of time, but with Canada, the main reasons we chose it was because they had the same problem between a determinant and a defense. They offered a modified standard of care, and then for their defense, they had an implied consent. Now, this started in 1965 with them, and consistently for over 45 cases was followed or cited. This is not anything close to the number of cases that we have in Australia to determine this. And what happened in Canada was, since they were only using case law, this progressed slowly. And what we found was they started with the defense, much how we are with our Civil Liability Act. But over the next 40, 50 years, they ended up finally deciding on going with the standard of care. The reason for this, guys, is mainly this. Why reconsider the same facts, the same evidence, and all the time in determining whether someone's liable or not, only to go through the defense, where you have to go through the exact same stuff, only to say, yeah, okay, it turns out he was liable in that section, but he's not liable now because this is slightly worded differently. They found it was a lot easier and more appropriate legally to simply go, if there is liability, there is. If there isn't, there isn't. And to save the defenses for super specific incidents that the law might not have foreseen. Whereas our approach and their early approach did go with having a blanket. Now on here, the Canadian determinant approach decided for a modified standard of care. They also use the reasonable person, but what they do is instead make the reasonable person a reasonable competitor. And they actually have this in their case law. So every sports case that they hear, whether it's a game of kick the can or a game of professional ice hockey, it's all going to be dealt with this in their place idea and these criteria that are actually spelled out in their case law, such as considering the speed of play, the atmosphere of the game, and the standards of fair play that surround the game. So they look a lot more about the spirit, and they look in depth on all these specificities. And the reason this is important is it deals with this policy of personal accountability, holding players responsible for some of the risks that they intended to take when they went onto the field. But it gets a bit murky because at one point we're balancing our responsibility for safety, and on the other hand, we have this awkward social utility, an imperative to win. Now, the social utility is introduced by the Civil Liability Acts in Australia. The idea behind it is to preserve the social utility of this sport. And what that's come down in the courts is preserve the imperative to win. For that's where we get our competitiveness from, and competitiveness is one of the great benefits that sport gives to our society. So that's what's missing here, the imperative to win consideration from the Canadian approach. And balancing this, we don't want to end up where everyone has to go around playing bubble soccer so that we're so safe, but we also don't want to ignore safety because that can damage our social utility as well from sports. If it's too dangerous, we're not getting a benefit from it as well. And we want to avoid this chilling effect that overregulation can have on sports by making competitors, instead of thinking about playing the game, more fearful for what's going to happen in the courts. So we need to find this perfect balance. And what we found was that balance comes from the Freeman solution. This was a US case called Freeman and Hale. And what they found was combine personal accountability with social utility. Define additional risk by its impact on the imperative to win. I'm going to read this out to you, and I apologize if it's a bit lengthy, but it's a risk that is not necessary or ordinary if its prohibition would neither chill vigorous participation in the sport nor alter the safety nor alter the nature of the sport. Essentially, they're using the personal accountability to be measured based on how much you impact the social utility and where that line should be drawn. What this means is we may see more reliance upon safety standards in the future, as safety standards are done by the industry themselves, thus avoiding any chilling effect on the sport. In addition, the safety standards present what are obviously foreseeable and not insignificant risks. I'm not saying every court case will be based upon this, but there's a strong chance that more cases as they come about, as sport keeps increasing, will end up with these safety standards being modeled. Finally, we need to examine the most recent Australian case called Dodge and Snell. In this case in Tasmania, a controversial decision was made where the dangerous recreational activity defense was thrown out on the fact that it was a professional player, and professional players can't take place in recreational activities as it's part of their scope of their employment. If this comes out to be true, safety standards, which were also relied upon partially in Dodge and Snell, could come about to be more important things for businesses, such as any professional industry in sport needs to consider that they are providing appropriate training and safety moves. If they have a recent change, they need to try and alter the muscle memory perhaps of the players so that they will tackle appropriately. These things all could come up in future court decisions, and thusly it is important to consider the legal limits to participant liability in sport. Thank you.